Save Our Children's Truth Commission? Great. Conspiracies, theories? I don't believe in them. So everybody, if you could turn to the second section in your book. If you don't have it, follow along on the screen. We're going to go to the last page in the second section, page 48.
Perhaps it would have been better for the contemporary history of civil rights had conspiracy renamed itself. The term still suggests something more diabolical or more risible than the rule of causation it represents. When conspiracy law inconspicuously entered into civil rights enforcement merely as a theory of causation under Section 1983, it seldom provoked strong response. It was only when conspiracy entered civil rights law as a seemingly autonomous cause of action under Section 1985-3 that it prompted concerted judicial effort to stifle its growth. Thus, the spontaneously generated doctrine of intracorporate immunity has all but strangled conspiracy actions against governmental actors and has done a fair job of suppressing private ones. Conspiracy law offers a valuable, if limited, contribution to the enforcement of civil rights. It helps snare those who artfully encourage violations of law while leaving the task of violating to others. Moreover, conspiracy law adds to the sanction of those who swell their strength and influence through collaborative efforts. If, as judicial critics fear, civil conspiracy is easy to allege, it is also difficult to prove. More often than not, conspiracy claims fall to the wayside during the course of litigation, or lose their practical significance as plaintiffs close in on the more easily detected perpetrators of constitutional wrongs. Conspiracy is distinctly a secondary remedy, but it is still a remedy with a purpose. When the Supreme Court eventually re-examines conspiracy law in the context of civil actions against government, it should recall that the Reconstruction Congress had governmental conspiracies in mind, even as it labored over its power to regulate private ones. It would be a dispiriting turn of fate if conspiracy law loses its historical connection to governmental action at the very time when government's capacity to conspire has increased to dimensions beyond the imagination of the 19th century mind.
Now let's start at the beginning, page 2, everybody. Page 2, if you'd like to join, I'll also have it on the screen. If two or more persons conspire for the purpose of depriving, either directly or indirectly, any person or class of persons of the equal protection of laws in any case of conspiracy set forth in this section, if one or more persons engaged therein do cause to be done any act or furtherance of the object of the conspiracy, whereby another is injured in person or property or deprived of having and exercising any right or privilege of a citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. Page 6, an overview of conspiracy doctrine. If you go to the second paragraph, highlighted is the gist of the crime is the agreement itself rather than the action pursuant to it. So stop and think, what does that mean? Now, Pinky and the Brain never do actually take over the world, but they did conspire. So continuing on to page 8, all the way towards the bottom third paragraph. Criminal conspiracy doctrine criminalizes behavior that would otherwise be permissible, as a comparison of criminal and tort conspiracy law reveals. So this is where it starts to get a little bit more confusing. Both the conspiracy and its unlawful object are punishable wrongs, which may be found independent of each other. So the last sentence, conspiracy liability does not exist without a tort. Thus, conspiracy or concerted action liability in the civil law imposes a form of vicarious liability, important term. Everyone, page 8. Whereby all persons who actively participate in the wrongful act by cooperation or request, or who lend aid, encouragement or countenance to the wrongdoer, or approval to his acts done for their benefit, are equally liable with him. Important. Page 9, Conspiracy Doctrine, where a conspirator is rarely found vicariously liable for the substantive offenses of his co-conspirators. Criminal law, private conduct, regardless of whether they acted under the color of law, who conspired to deprive others of equal protection or equal privileges and immunities under the law. So that's where they start to show where this 42 USC 1985 can actually start inhibiting First Amendment rights, freedom of speech. So it is specific to civil rights. State civil rights, federal civil rights are pretty much the same, but it must be privileges and immunities. But what does that mean exactly?
Rights. You can't make a round square means it can't be done. You can't kill Fred means it would be wrong to do it. But do we have natural rights? By nature, we have spleens. If you cut me open, you'd find my spleen. But you wouldn't find any of my rights. So let's see if we can figure out what natural rights might be. If you watch any TV at all, you probably know that you have the right to remain silent and to have an attorney present during questioning. But not if you live in North Korea. The famous right to remain silent is a legal right. It's a feature of the legal system we happen to have. People in other countries may or may not have the right to an attorney. Similarly, if you're 18, you have the right to vote. But not if you were 18 in the 1960s. In 1971, the Constitution was amended to extend voting rights to 18-year-olds who had previously not enjoyed that right. A few years later, 18-year-olds lost the right to drink beer. These are examples of legal rights or constitutional rights. We have whatever legal rights the lawmakers say we have, and they can change at any time. But the Declaration of Independence refers to inalienable rights. Those aren't the sort of things that could change. Are there any such things? Because we get legal rights from the lawmakers, people sometimes make the mistake of saying that rights come from the government. But when the American colonists declared independence from Britain, they got rid of their government. Did that mean that they no longer had rights? Nope, that's the whole point. They thought that they had rights that didn't come from the government. Although constitutional rights are products of constitutions, the rebellious colonists thought that the right to live and be free was a right that we had by nature, and the point of even having a government at all was to protect those rights. Protecting rights we already have. This is the essence of classical liberalism and the revolutions it inspired. In the old days, people claimed that kings ruled by divine authority, so the king's rule was natural. Rights were permissions from the king, an artificial construct. To the classical liberal way of thinking, the right to live and be free is natural, and governments are artificial. Institutions created to help protect or enforce those rights. So it turns the old model completely around, literally a revolution. But why should we think there's a natural right to live and be free? One way to think about it is this. Is it your natural condition to exist only as a means of sustenance to another organism? Or do you have an independent existence? We're all Homo sapiens. The old model had us thinking that the so-called nobility were literally a better breed of person, naturally suited to rule over the so-called commoners, whose inferior dispositions made them suitable only to serve. I'm pretty sure that's not true. What do you think? So, if the right to live and be free is natural, then governments are doing well when they protect your rights and doing wrong when they violate your rights. As much as possible, then, the legal system should create rights that are compatible with and don't contradict your natural rights.
So that's it, you guys. Is there any questions? Let's hope you didn't learn too much. Haha.